This program is brought to you by Emory University.
Okay, good afternoon, everybody. My name is Araceli Jacobs. I work for the Supreme Court Committee on Justice for Children. I'm here on behalf of Michelle Barkley, who will be joining us a little bit later. I just want to thank you for coming here to hear Director Davidson's talk today. Just a few housekeeping items. Please turn off all cell phones. Make sure those are turned off. We don't want them to interrupt the program. This program is going to conclude today at 3:45. We will have a 10-minute break partway through the program, and I'll be able to announce that for you. So if you are unable to get food and things like that, you'll have a break so you can do that. Make sure you register at the table in the hallway, pick up materials, and sign up for CLEs if you needed them. Also, program evaluations will be given out during the break. Please turn those in. Those help the Barton Center and my office, the Supreme Court Committee on Justice for Children, to decide what programs that you need for the next Child Welfare Legal Academy. Certificates will also be available at the end of the program for those who are pre-registered online, and you'll get, those of you who had to register today at the table, you'll receive your certificate after the program. Parking validations are good for 3-hour parking only. If you remain in the deck longer than 3 hours, you have to pay the difference. And if also, at the end of the presentation, I'm sure Howard will have time for questions, and we'll have you go to the mics to deliver that question just so we can pick it up. This event is being live streamed, so we want to be able to, for our audience who are out there in the virtual world, to hear your questions and also Howard's answers. Restrooms are located in the outer hallways, and also we have recycling bins there too, so please dispose your trash appropriately. Information about the future legal academies will be on the Barton's website at barton.net. And I think that's about it. I'm just so pleased today to have the opportunity to introduce Director Howard. We had a good time today. We had an opportunity to talk about some of the changing practice in child welfare and some of the policy issues that are emerging as the federal government continues to pass new legislation. So I think we're very privileged here to have him here. Director Davidson has been in this field for over 40 years, so he has a wealth of experience. His bio is in a part of the packet that you got today, so I won't belabor it, but we're very excited to have him here. Thank you so much for being here. Without further ado.
Thank you. Thank you very much. This is actually, I think, the second time I've been on this stage. A number of years ago, I believe it was here at the law school, there was a number of years ago, there was a program on the Convention on the Rights of the Child, and hosted by the law school and the Center for the Study of Religion. And I was very privileged to be a part of that program, particularly because a fellow speaker on the program was Jimmy Carter. So it was a great thrill to meet him and to talk about children's rights issues and the Convention on the Rights of the Child, which, of course, the U.S. still hasn't ratified. And I appreciate the Barton Child Law Center and the Court Improvement Program for the state to invite me here to speak about this topic. I have admired the work that's being done in Georgia related to the protection of children, and I hope that I can continue to be of assistance, and my program in Washington can be of assistance. I direct a program called the American Bar Association's Center on Children and the Law. I have a staff of attorneys who work as specialists on training, consulting, technical assistance related to the child protection system, foster care, and the courts, and how they deal with abused and neglected children, and how to improve that entire process through practice reform, through policy reform, and through law reform. So I've been, as Araceli mentioned, I've been doing this work for a long time, and this subject has been of particular interest to me. 50 years ago, if somebody had said, what are we going to do about records that are being kept about abuse and neglect of children, nobody would know what you were talking about. I mean, There was very little around the country that would have looked like Child Protective Services 50 years ago. We didn't have the structures in place, we didn't have the laws in place, and so we hadn't thought really about the issue of access to government records related to the abuse and neglect of children. So I'm going to start with some of the evolution on this issue with a timeline, and I will discuss certain elements of this timeline with you later. And you have handouts, I understand, of these slides, which is great. Thank you, Emory folks, for doing that. So let's start with 1974, because we have recently marked the anniversary of the Child Abuse Prevention and Treatment Act of 1974, CAPTA as it's called, which was last reauthorized in 2010. It is the primary federal law with the words child abuse in the law, and it provides funding to states related to programs addressing child abuse and neglect, but it's very little money in this law. It's about $25 million divided up among the states in state grants. And to be eligible to receive that funding, in addition to another pot of money that's for prevention of child abuse and neglect, to get that money, states have to comply with the regulations and policies underlying CAPTA, with the things that are in the law that tie state funding from the federal government to the states to certain things happening in the states. For example, since 1974, this law has said that every child who is the subject of a judicial proceeding related to child abuse and neglect must receive the appointment of a guardian ad litem. Now, in some states, that guardian ad litem is not an attorney. But in other states, the guardian ad litem is an attorney, or they don't use the term guardian ad litem, they just use the term attorney for the child. That's a requirement to have that legal representative for the child. It's a requirement in the federal law of CAPTA to receive the funding that comes through the U.S. Department of Health and Human Services. So the 1974 Act, when it was enacted by Congress, contained another requirement that states must preserve the confidentiality of all records. Let me be more precise and read you what the requirement was for states to be eligible for federal funding. States were required to provide for methods to preserve the confidentiality of all records in order to protect the rights of the child, his parents, or guardians. The word all is unequivocal. Preserve the confidentiality of all records. Now, the Department of Health and Human Services recognized that although one must preserve confidentiality, there are those individuals and institutions that might need access to that information. So the Department of Health and Human Services published regulations, which are found at 45 Code of Federal Regulations, section 1340.14, 1340.14, 45 CFR, which gave the states the option of disclosing child abuse record information to a set of enumerated individuals and entities. Or actually, 11 plus one. There's 11 plus another option that I'll get to. So I'll read you the list of who the HHS said could get child abuse records. This is back in implementing the 1974 law. So first, again, if there was a state law authorizing it, and that's a requirement that you couldn't give out the information in a child abuse and neglect report or record without it being authorized by statute. But here is the list that if you had a statute you could release to. The agency or organization and its designated multidisciplinary case consultation team legally mandated by federal or state law to receive and investigate reports of known and suspected child abuse and neglect. 2, a court under terms identified in the state statute. 3, a grand jury. 4, a physician who has before him or her a child whom the physician reasonably suspects may be abused or neglected. And those words, has before him or her, suggest that what Congress wanted physicians, pediatricians, emergency room doctors to be able to do is when they had a child who came into the emergency room and they were finding injuries, to be able to contact the agency and find out if there had been prior reports of abuse or neglect of this child. So it was, in its sense, a diagnostic tool that was being made available to physicians, but again, only when the child was before them and a reasonable suspicion of abuse and neglect was there. The next is a person legally authorized to place a child in protective custody, again, when they have the child before them who they suspect of abuse or neglect, in order to determine whether to place the child in protective custody. I would imagine that would include law enforcement, for example, who in many states had the authority to take children into protective custody, as well as child welfare agencies. The next, an agency authorized by a properly constituted authority to diagnose, care for, treat, or supervise a child who's the subject of a report of abuse or neglect. So the treatment providers, if you could have a statute that allowed access by treatment providers to child abuse and neglect records. And we'll come back to that again. These are all discretionary options for states if they pass a law that provides this access. Next, a person about whom a report has been made. So if somebody reports you for child abuse and neglect, you have a right to know that there's been a report made on child abuse and neglect. But HHS said there must be protection for the identity of any person reporting known or suspected child abuse and neglect, and any other person where the person or agency making the information available finds that disclosure would likely endanger the life or safety of that person. So protection of mandatory reporters, of the identity of mandatory reporters, built in to these initial HHS regulations on CAPTA. A child named in the report or record alleged to have been abused and neglected, or his or her guardian or guardian ad litem. An appropriate state or local official responsible for administration of child protective services or oversight of enabling legislation for carrying out their official functions. And finally, a person, agency, or organization engaged in bona fide research or evaluation work, but without identifying individuals named in a report or record. And then the states were given still one more option, to authorize by statute disclosure as determined by the state for the purpose of carrying out background or employment-related screening of individuals who may be engaged in specific categories of child-related activities or employment. So you had these options to release information, but only if a state law were to specifically do so. So that was 1983. Notice that the statute came out in 1974, and the regulations didn't come out until 1983 with these exceptions. By the way, in 1974, FERPA, the Federal Educational Rights and Privacy Act was also enacted. That's relevant to our discussion. I'll talk about FERPA later. So now let's move to 1996. In 1996, HIPAA, Health Insurance Portability, I never get the name right. HIPAA was enacted, dealing with the privacy of health records. And that same year, there was a death of a child due to child abuse in New York City, a girl by the name of Elisa Esquierdo. And that prompted the New York State Legislature to enact what I think may have been the first state law on public information release after a child dies allegedly due to abuse or neglect, to open up the records for the media, the news media, for example. And it's interesting, that case got a lot of attention. I can't remember the year, but there was also, around that time, or maybe earlier, a series of articles about child fatalities in the Atlanta Journal-Constitution that highlighted child deaths due to abuse and neglect. And so there was a lot of attention to the need for the public to understand why children die of abuse or neglect, what might have been done to prevent the deaths of children due to abuse or neglect. And in 1996, Congress amended the Child Abuse Prevention and Treatment Act to allow Child Protective Services to release some information after a child dies. We'll talk more about that. So moving on from 1997 to the present, HHS and the Children's Bureau, which is the part of the Department of Health and Human Services that implements the Child Abuse Prevention and Treatment Act, no longer issues regulations under that federal law. The way they set policy is through something called policy interpretation questions. And they list those questions and answers on the website of the Department of Health and Human Services in something called the Child Welfare Policy Manual. So in 1997, or sometime since 1997, since 1997, they have been issuing questions and answers about what can you release, when can you release information. So this is a moving target where the Children's Bureau of the Department of Health and Human Services is helping states understand what is permissible, what is impermissible in terms of the release of information related to a record of child abuse and neglect. I think it's important to note that there have been no changes to the regulations related to the Child Abuse Prevention Treatment Act since 1990. In 2002, HHS issued a privacy rule related to clarifying what remain very strict alcohol and drug treatment patient information confidentiality. And I'll talk more about that because a lot of child abuse and neglect cases involve parents with alcohol and drug problems who engage in treatment, and it's relevant to identifying the progress of the family and of the parents in treatment for the agency and the court to know how the parent is doing. So there's this issue of access to drug and alcohol treatment records, which have very tight privacy restrictions under federal law. So now on the right-hand side, in 2003, by 2003, there was concern by Congress that all of this restriction on access to child abuse and neglect record information was endangering children. So Congress amended CAPTA. CAPTA gets amended every 5 to 8 years. So in 2003, Congress was amended to add a new provision mandating release of certain information. And I'll read you that text. that states, in order to qualify for captive funding, had to have provisions requiring the disclosure of confidential information to any federal, state, or local government entity or any agent of such entity that has a need for such information in order to carry out its responsibilities under law to protect children from abuse and neglect. So you suddenly had this requirement to share information with those agencies that needed that information to carry out responsibilities under law to protect children from abuse and neglect. Clearly, law enforcement has responsibilities under law to protect children from abuse and neglect, but there's certainly others that might have that responsibility as well. In 2006, Congress passed something called the Adam Walsh Act. I'll talk more about that in a little while. And that addresses another issue that I'm going to talk about this afternoon, which is not the disclosure of information held by Child Protective Services, but access of Child Protective Services to information held by others to protect children. In 2008, a report was issued by a private non-governmental organization called State Secrecy and Child Abuse Deaths in the United States. And a second report was issued in 2012, and I'll talk about that more in a few minutes. In 2010, the U.S. Senate, in connection with CAPTA reauthorization, the latest CAPTA reauthorization, issued a report calling on HHS to issue regulations to guide states on what must be released to the public after a child dies. Those regulations have not been released, but HHS has continued to clarify for states through the policy interpretation questions what must be released, and I'll get to that in another slide. And finally, in 2013, Congress passes something called the Uninterrupted Scholars Act to ease accessibility to school records by child welfare agencies. And also the Government Accountability Office issues a report on the importance of human services agency data sharing. So you have a continued interest by Congress and by organizations, both within government and outside of government, about the access questions related to records and the sharing of records across agency boundaries. Now, the area that has garnered the most controversy is what do we release in terms of public records after a child dies, or as the law calls it, a near fatality, when a child almost dies. And in 1996, as I have mentioned, CAPTA was amended to specifically authorize release. It allowed for public disclosure of findings or information held by Child Protective Services. The Congress deliberately didn't say that states were required to release or counties were required to release information. There just had to be provisions allowing for public disclosure, and Congress left open whether it was to be done upon a request, and they didn't specify what was meant by findings or information. So there was an ambiguity in this 1996 amendment to CAPTA about, well, what is it exactly the Congress is telling the states when a child dies about what can or must be released? And although I mentioned that there were these regulations that preceded this amendment, the regulations have never been updated. So they weren't changed to answer the question, what is this 1996 amendment really telling the states to do? So it's only been handled by these policy interpretation questions. So the policy interpretation questions, or PIQ, the relevant policy interpretation question, which I will talk about on the next couple of slides, the earlier set of policy interpretation questions defined what do we mean by a near fatality of a child due to abuse and neglect? What do findings or information really mean? That a report which had the requisite information released by a child fatality team, that could just simply giving a report that summarizes activity related to a child who later died, that simply that report could suffice as public disclosure. There were news organizations that tried to get, including through lawsuits, getting actual access to case records. There may have been such lawsuits in Georgia. I just don't recall. But there were lawsuits filed by news organizations to get open access to government records related to a child's death. The Department of Health and Human Services also said that Child Protective Services only had to release information when it was requested, and then when it was requested, then release was mandatory. And that Child Protective Services need not turn over the entire case records, nor to give out the child's name, date of birth, date of death, or information on siblings or other children in the home. But there remained confusion about what has to be released when a child dies. So finally, in September 2012, the Department of Health and Human Services says when a child dies who is under the care of, in the custody of, or had an open case with Child Protective Services, here's what has to be released at a minimum upon request. And they came up with this list of 6 things. I won't read it, but this at least, finally in 2012, gave clarity to what elements are required in the release of information after a child dies due to child abuse or neglect, or suspected child abuse or neglect. And it's a good list because it talks about the causes or circumstances related to fatality. It talks about past reports. It talks about the investigations that led to the of the abuse or neglect that led to fatality, the results of the investigation, and any services provided pertinent to the abuse and neglect. But it still leaves a lot of flexibility for the Child Protective Agency in terms of what to release. And there were members of Congress that were very unhappy with what HHS did. Earlier in 2010, Congress issued a report, the U.S. Senate issued a report stating that they were aware that not all states were in compliance with the disclosure requirements under CAPTA, and they called on HHS to develop clear guidelines in the form of regulations instructing states of their responsibilities to release, and that HHS should provide technical assistance to states on full disclosure provisions. To date, there are no regulations and no more guidance on disclosure of information after a child dies. I know this is esoteric stuff, but when states have a big problem with child fatalities due to alleged abuse and neglect, it has provoked a lot of public scrutiny of the Child Welfare Agency by the media. And so this issue does remain one that has significant public policy concerns. So for example, in this year, Florida enacted a new law, Chapter 224, with provisions stating 5 things that must be disclosed after a child dies and requiring information to be posted on the Child Welfare Agency's website. So, why did Florida pass this law? Well, there have been a series of stories in the Miami Herald, and this harkens back to the Atlanta Journal-Constitution articles of several decades ago about this, in this case, how 477 children died of abuse and neglect after falling through Florida's protective net, a story of missed opportunities. So this series of stories, affected the legislature, and now from a state that was criticized, in the case of Florida, for not opening up information to the media and to the public about child deaths due to abuse and neglect. Now there's a great deal of transparency. So the Florida Department of Children and Family Services actually has a website that you can go to with all sorts of information on every child death. The date of death, the age, the causal factor, whether there was prior agency involvement, and an explanation of the child death situation, and a breakdown of the types of maltreatment that led to the death. And this information is regularly updated on the Florida Department of Children and Families website. And it's very significant how a state can change from one that has been uncomfortable sharing information about what happened in terms of a child and family's involvement with protective services, to change to an openness. And that's happened in a number of states, and I'm going to talk about how at least one organization measures that. So in 2011, the Government Accountability Office, the Federal Government Accountability Office, issued this report, Child Maltreatment: Strengthening National Data on Child Fatalities Could Aid in Prevention. There is a real concern that we don't collect adequate and accurate data on children who die as a result of abuse or neglect. And that's what this GAO study found. That the states were not gathering data from other than Child Protective Services. They were not going to multiple sources to get that information. So the GAO report recommended strengthening data quality, sharing best practices, collecting better national data, including on near fatalities, and as a result, in 2012, Congress required that every state's child welfare plan describe the sources that states were using to compile information on child maltreatment deaths. And to the extent that they didn't include information from vital statistics, from child death review teams, from law enforcement agencies, from medical examiners, from coroners, they had to explain why they're not including that information and how they're going to later include it so they could get an accurate understanding of the scope of child abuse and neglect fatalities. This is a continued issue that there's now a federally, congressionally created commission looking at, and I'll mention that in a couple of slides. So I mentioned that there was an organization that actually looked at how the states did in terms of sharing information when children die as a result of suspected abuse and neglect. And that report now has been in 2 editions. It's called State Secrecy and Child Deaths in the U.S., the organizations of the Children's Advocacy Institute at the University of San Diego School of Law and an organization called First Star. And you'll be happy to know that in the 2nd edition, because of some legal changes in the state of Georgia, that in the 2nd edition, the most recent edition of this report, Georgia went from a very low grade to a B in terms of because of Georgia had earned a grade of F in the earlier report. And in this 2012 report, it went from F to B. And the reason was, I think I have a slide on this, actually. So here is the reason. So Georgia has a state policy regarding public disclosure, so they got 40 out of 40 possible points. The state policy is codified in statute. They got 10 out of 10 points. The ease of access. The policy requires mandatory disclosure. Any adult requesting information regarding findings or information about a case shall have reasonable access to such records. So they got 20 out of 20. What is the scope of information authorized to release? Here they got the state got 6 out of 20. The information authorized is vague and unclear with a moderate restriction. So basically the law says give out the available facts and findings. So the Children's Advocacy Institute didn't think that was sufficient. And then the last thing they look at is whether child abuse and neglect court proceedings are open. And Georgia has a law on open dependency proceedings. So they got 10 out of 10. I have some issues with this report and this report card on states, because I think there's things that we should be looking at related to release of information after a child dies that these organizations are not looking at. For example, should case reports be de-identified so they leave the outcomes of children and family members, but also the names of service providers and provider organizations out? Well, there is an opinion that the purpose of child death review is to improve the system, but not to assess blame. So reports that are compiled on a child death may not say anything about who the service providers were, who were the organizations that were supposed to be aiding this family. And I think that's a real concern. You know, every state now has some sort of a review process for externally or internally reviewing deaths of children due to abuse and neglect. And the question is, how secret should that process be? How open should the records be that are being looked at when a child dies due to abuse and neglect? The confidentiality argument is that everybody will participate more openly in looking at a child death case if written reports will not identify individual agencies and service providers. That if you were to do that, it would frustrate the openness of sharing of information. You know, the process is not about assigning blame. The process is identifying and publicly disclosing system shortcomings. We need to know if systems are failing kids, if government agencies with responsibility to protect children are dropping the ball on their responsibilities. And we need to use this process in a way that is going to allow the public to understand what needs to be fixed. And sometimes you need to name organizations that have dropped the ball or agencies that have dropped the ball, in my humble opinion. So I mentioned there's a government entity that is now looking at this. This is a commission to eliminate child abuse and neglect fatalities, and I was privileged to be invited to testify before the commission at their July meeting. And this is a commission where members are appointed by the President of the United States, by the Majority Leader of the Senate, and by the Speaker of the House of Representatives. So this is a pretty high-level blue ribbon panel that's looking at the issue of child abuse and neglect deaths. So here's what I said during my presentation on July 11th. I said, to prevent child deaths, CAPTA must evolve from a you must keep confidential focus to a you must disclose focus. While an amendment to CAPTA was passed in 2003, which you've heard about, to promote mandatory disclosure, older regulations from HHS requiring states to criminalize disclosures and the lack of guidance to states on permissible and mandated disclosures may actually be working to inhibit full implementation of that provision. The fact is that states do have laws, and HHS actually in its original regulations for captives said that states must have laws that make it a crime to disclose protected child abuse and neglect information. Nobody wants to go to jail for disclosing child abuse and neglect information, and it may really inhibit a legitimate and important sharing of information from one agency to another agency. The original captive state requirement, as I have said, focused on keep records private with very limited exceptions to protect the rights of the child and the child parents. Out of concern that this provision endangered kids, I've mentioned that in 2003, CAPTA was amended to require state provisions mandating disclosure to any government entity with a need for such information. So this is kind of recapping what I've talked about. But again, there's not been adequate guidance to the states on this disclosure provision of 2003. And the regulations which require states to criminalize disclosures that lack statutory authority is still on the books. The regulation is still on the books, and it can inhibit this disclosure provision. This is the point, I believe. No, it's not the point yet. So, Pennsylvania. So, sharing information is something you should be dealing with in statute. First of all, CAPTA says there has to be statutory authorization. So, in Pennsylvania, this year, effective January 1st, there is a new law in Pennsylvania that mandates that healthcare professionals provide child welfare agencies with all relevant medical information regarding a child's past and current health, including information on follow-up examinations, information on the child's treatment, relevant medical information on other children in the home, and parental consent for the release of that information to Child Protective Services is not required. Who knows what federal law necessitates that Pennsylvania pass a specific law to do this? There's a federal law that would stand in the way if you didn't have this statute. Anybody know what federal law that is? HIPAA, which I'll talk about in a little while. So HIPAA does allow states to enact these kinds of statutes to open up sharing of information between healthcare providers and child welfare agencies. So this 2014 law also mandates that child welfare agencies, upon a health provider's request, that they provide information suggesting any information suggesting an adverse medical effect on the child, findings of any investigation of abuse and neglect, including if a doctor's report was unfounded, services the agency is providing the child, and the identity of other medical service providers so that medical records can be shared for health care coordination. So here you have a state legislature saying, we've got to assure that there is an openness between the child welfare agency and health care providers that works both ways to assure that we are addressing the need to know of child welfare about the health situation, and likewise the health providers to know what's going on related to the Child Protective Services, Child Welfare Agency functions, particularly anything that they learn that can endanger the child. It's a very unique statute, and I expect to see more states do this sort of thing. I skipped over this slide, and before I do this slide, I think it is time for a break. Would I be right? Okay, it is time for a 10-minute break. So there's food outside, and we'll come back in 10 minutes, and I will complete the presentation.
Thank you so much. Thank you so much, Howard. And we will take a 10-minute break. And also, if you did not register when you came in, please go to the registration table and register. Okay, we're going to come back together. Those of you who are in the hallway getting a snack, please return to the auditorium so we can start the second half. Program evaluations have been put on your table, so make sure that you hand those in at the registration table before you leave today. Now let's hear the second half of the presentation by Dr. Howard Davidson. Thank you.
Thank you. You know, this information is very technical and dry, and it's very hard to make it, what's the word, sexy, to make it something that is easy to talk to about or understand, because there's a lot of complexity to the policy and to the law. And yet it's very important stuff, because this is all about, in my view, protecting children, saving children's lives, and information sharing and information access is an important part of that responsibility of government. And the federal government has not given enough attention, and I think this is why it's so important that we have this congressionally created commission on child abuse and neglect fatalities, is we haven't given enough attention to how confidentiality restrictions may be endangering children, how we may be not appropriately sharing information both from Child Protective Services and with Child Protective Services. So going back to the slide, when federal regulations were published, and last amended in 1990, there were lots of appropriate information sharing aspects that weren't addressed in the regulations. For example, sharing Child Protective Service information with licensing agencies. Somebody wants to get a family daycare license. Don't we want to know if they have a substantiated case of child abuse and neglect? Somebody wants to operate a group home. Don't we want to know if they have a history of substantiated child abuse or neglect? But the regulations say nothing about licensing agencies. Well, for the past 25, 30 years, we've had children's advocacy centers. They get involved in cases primarily of sexual abuse. Don't they need to know the history, the family histories with Child Protective Services of a case that may be before the Children's Advocacy Center? Nothing is said about that in the law or regulations. I've written about the need for guidelines on collaboration between investigators of animal cruelty and Child Protective Services, because when we find cruelty to animals in a home, we often find cruelty to children, we often find domestic violence in the home, and there should be ability to share information between animal control officers and Child Protective Services. Clearly, policy and law says nothing about that. There are agencies that have protective responsibilities for persons with disabilities or older adults, government programs to protect the elderly from abuse, sharing information from Child Protective Services to Elder Protective Services. Nowhere is that addressed in law or policy at the federal level. Reporting to the military, from Child Protective Services to the military when there's a military family that may have been reported for abuse or neglect. Law says nothing, policy says nothing about that. Reporting to tribes an incident of alleged abuse and neglect involving a child who's a member of a tribe. Reporting of domestic violence to appropriate authorities. Checking records for civil orders of protection. I'll say more about that now. I do not understand why child protective agencies and dependency courts do not have easy access to whether or not civil orders of protection have been issued for a family when child abuse and domestic violence are so interrelated. But again, what inhibits passing laws and policies at the state and local level to do these things, what inhibits that is we don't have the federal policy guidance or the federal law to support this greater access and sharing of information. The second bullet, highlights a number of other areas where record access and information access is probably restricted because we haven't clarified federal policy adequately. So if someone, instead of diagnosing abuse and neglect, remember that exception that a doctor could get information if they had a child before them that they suspected of abuse and neglect? What if the doctor's not doing diagnostic or treatment work, but what if it's a health professional or a school official who's doing therapeutic interventions with a child? What about disclosures to probation officers who are supervising offenders of abuse and neglect? Isn't it relevant if someone is on probation and they have and they've been reported for and an investigation substantiates abuse and neglect that they've committed? Isn't it important for probation officers to be able to share information with Child Protective Services? Again, these questions of information sharing are only going to be advanced through looking at the policies and how we're going to improve the policies. It's permissible if states have laws, to release child abuse and neglect information to properly constituted agencies who are authorized to diagnose, care for, treat, or supervise a child after a report of abuse and neglect. That's never been defined by HHS. Does that include schools? Does that include private agencies providing foster and group care? Does it include CASA programs, medical examiners, juvenile justice agencies? Should we be modifying law and policy to permit foster and kinship care providers to have information about abuse and neglect? There are children placed with foster parents and relative caretakers who are never told the histories, the abuse and neglect histories of the children that are being placed with them. And one of the reasons that the foster care providers and the kinship care providers may not be getting this information is some belief that may be grounded in reality that they're not allowed, that child welfare agencies are not allowed to share record history information with providers. It's crazy. Sharing information with police should be clearly permitted for both protective custody, but not just protective custody, for any child-related purposes. There should be open sharing. It should be very clear in policy and law, open sharing of information between law enforcement and child protective services. There should be not just cross-reporting from one agency to another, but a sharing of information to assure that all relevant information about the child and family are known. Citizen review panels, employment licensing screening. There is something in the original regulations about employment licensing screening, but citizen review panels getting access to this information hasn't been addressed in the regulations. Child death review teams, foster care review teams, children's ombudsman, child advocate offices. There should be clear federal guidance about the ability of, for example, the Office of the Child Advocate to obtain information from Child Protective Services records. So I have, and this is now recommendations that I made to the Federal Commission on Child Fatalities. So what can we do at the state level to improve information sharing, to assure better accountability, to assure that children are protected through access to information that's needed to protect children? Well, one reason to share information with people who report child abuse and neglect is so that they will continue to report child abuse and neglect when they suspect it, and to have confidence that when they report child abuse and neglect, that it will be promptly investigated, and that the outcomes will address the problem that was led to the report of abuse and neglect. So I certainly believe states should mandate feedback to reporters of child abuse and neglect, particularly mandated reporters, at least when those reporters request it. There should be nothing that stands in the way of Child Protective Services telling the reporter, the original reporter of abuse and neglect, that an investigation occurred, here are the results of the investigation, and here are the actions the agency took. And that is really important if we want to continue to encourage doctors and teachers and psychologists and social workers to report child abuse and neglect. They need to get feedback. They need to know that the system is functioning as they hope the system would be functioning. We need to do a better job sharing information across state lines. Families move. And the information record as sharing and access to information on a cross-state basis should be clearly mandated when a child welfare agency asks for it, when a law enforcement agency asks for it, because these parents who abuse and neglect their kids move from one state to another state. The third recommendation I made has to do with disclosures to the public, other than in fatality cases. So there are a lot of aggrieved parents who think that who believe their rights were trampled by Child Protective Services, by the Department of Children and Family Services conducting an investigation that violated their Fourth Amendment rights, that, trampled on their rights, that took their kids away without just cause. And sometimes those families go public with their stories of how terrible Child Protective Services was in terms of mistreating their family. States, I believe, should consider, and CAPTA should permit, states to pass laws that permit Child Protective Services to tell the public, in a case that's already been disclosed by the family, what it is they did. And Alyssa's law that I mentioned at the beginning in 1996, following a very publicized child death, allowed public disclosure even in non-death situations, as long as the commissioner director finds it would be in the best interest of the child. No, it permits disclosure as long as it would not be, let me back up. Disclosure is permitted as long as the commissioner of the agency finds that it is not contrary to the best interests of the child, to release that, not contrary to the best interests of the siblings, and not contrary to other children in the home, so that the agency doesn't have to stonewall. The agency doesn't have to say, confidentiality prevents me from talking about this case. The agency should have legal authority granted by a legislature to say what it did in a particular case when that case has already been made public. We need to restore confidence in our government child protection systems, and one way of doing it is allow the agency to come out from behind the wall of secrecy. Number 4, there should be explicit legal authority for public release of information about children missing from foster care, group care, or homes where they've been under protective supervision. There's new federal law that was signed by President Obama at the end of September that actually mandate states promptly reporting children who go missing from care. There are states that actually post the photos of kids missing from foster and group care on their website. And I'm told, at least in Fulton County, that when children go missing from care, that the agency very promptly reports those children as missing to law enforcement and to the National Center for Missing and Exploited Children. So it's very important that we not allow confidentiality laws and the interpretation of those laws to prohibit the reporting of a child who may be under the care of Child Protective Services or whose family or case is being handled by Child Protective Services, and that would restrict Child Protective Services from reporting that child as missing. Number 5, state laws should provide immunity protections for those that CPS asks to assist it in helping children. So we did actually a report on this at my center. Congress mandated in a CAPTA amendment that there be a report from the federal government, there be a report on how fear of liability may inhibit professionals to work on child abuse and neglect cases. Not reporting of child abuse and neglect cases, but to actually work on handling those cases when they're referred, those cases, by the Child Welfare Agency. So we did this, we worked on this report, and it is available online if someone is interested in looking at that report. It's called Immunity from Prosecution for Professional Consultation and Suspected and Known Instances of Child Abuse and Neglect. It came out in June 2013. And what we essentially said is that state laws need to improve immunity protections for those, for example, pediatricians or mental health professionals who are requested to provide information back to the agency on how those children and families are doing. They need to be open with sharing information about providing treatment without fear that parents are going to sue them over the release of that information to Child Protective Services. So some states actually have laws that extend the immunity that is given to reporters of child abuse and neglect. That is, if you're a professional and you report in good faith, you make a report of suspected child abuse and neglect, you are protected by immunity provisions in all 50 states. You are immune from liability. But if you assist Child Protective or Child Welfare Authority, agencies in providing services to families, in most states you don't have that same kind of liability protection. And some states extend that protection beyond the act of reporting. Number 6, we need to assure that we get the information we need, not just by laws that will allow us to get that information, but to work with families, to work with parents so that they understand how important it is that the Child Welfare Agency access information. And so I have proposed that there be development, and lawyers can play a real role in making sure that these are good, are appropriate, understandable release forms, that parents can clearly understand how to consent to the release of information, of otherwise confidential information, acknowledging that there are protections under HIPAA, protections under FERPA, protection of substance abuse records, but that parents recognize that it's important for the welfare of their children that the agency have access to this information. Not all parents will sign those consent forms, but if they knowingly and voluntarily and knowingly consent, that's one way to assure the access of that information. So we need to look at what consent and release forms are being used now and whether they're adequate to address the HIPAA, FERPA, and substance abuse treatment. And I'll talk about those 3 federal laws in a few minutes. I don't recall what Georgia law is on this, but there's some states where legislatures have said that you've got to destroy records of unsubstantiated reports of abuse and neglect. You know, it's crazy because even if the agency itself can't access a history of 10 reports that were made, even if they were unsubstantiated, in deciding what it is they're going to do about report number 11 and how they're going to handle report number 11, if you don't have that prior history information, your hands are being tied. And so there still are states that misapply something in CAPTA, and they erroneously construe that if a report is investigated and found to be unsubstantiated, that they have to take it out of the case records. It can't be accessible even for internal agency use. That's absolutely crazy. Number 8, I've already talked about this. There needs to be a mandate for cross-reporting from Child Protective Services to police and prosecutors, and vice versa, so that physical and sex abuse cases, if they come into the police, Child Protective Services got to know about them promptly. If they come into Child Protective Services, law enforcement needs to know about them immediately. Many states have those laws. Georgia may have such a law. I don't recall. Do you know if there's a law mandating cross-reporting between Child Protective Services and law enforcement in Georgia? Anybody know the answer to that? Yeah. Right. It really is important vice versa, because law enforcement may certainly encounter a family where there's a crime of physical or sexual abuse. Child Protective Services got to know about it immediately. Now, even without such a law mandating cross-reporting, I assume that law enforcement would notify Child Protective Services, particularly if a child has to be removed, right? Well, as I say, I think that should be clearly mandated. Prompt cross-reporting should be mandated. Number 9 on the list, sharing of information at family team meetings. In Georgia, they may be called family group conferencing, family group conferences. Does anybody know what they're called when the Child Welfare Agency brings the whole family together? Family team meetings? Okay. There should be an ability to share information with the family about what's going on in terms of abuse and neglect. And the agency may feel that its hands are tied to reveal, in some ways, why are we here? You know, somebody reported this child as being physically abused. But we can't talk about that because we're disclosing confidential information. At least in New Jersey, they actually passed in their statute a provision allowing that information to be shared at these team meetings. And now I'm going to talk about the Adam Walsh Child Protection and Safety Act of 2006. And there are a number of provisions, and this law is mainly about sex offender registration. And it's a very important law in terms of tracking sex offenders. But it has provisions that are not as well known related to child protection, to Child Protective Services. And so I wanted to highlight those because I think we need to do more to implement the provisions of the Adam Walsh Act that Congress gave agencies the discretion, the authority to use to protect children. So some of you may know that this law, the Adam Walsh Child Protection and Safety Act, required Child Protective Service Agency central registry checks from all states where a parent lived in the last 5 years for prospective foster and adoptive parents. But it also gave Child Protective Services agencies the opportunity to directly access the FBI's National Crime Information databases. So why is that important? The NCIC, National Crime Information Center database, has information on felony arrest, convictions, sex offender data, probation, parole information. It's a huge amount of data on there. And there's potential child safety issues that might cause a child protection agency to want to look at that data. Does a parent, let's say there's a substantiated case of child abuse, neglect, and the child is removed from the home, and the agency's plan is reunification of the child, but they want to know the return of the child home would be safe. So they want to find out who's in the home besides the parent. Well, mother's boyfriend is in the home. Don't you want to know if that mother's boyfriend has a criminal record, a criminal history background that would suggest that the child might not be safe returning to that home? So I believe that child safety can be enhanced by the Child Protection Agency getting access to the NCIC and finding out, are there circumstances, I believe this, by the way, also in terms of access to civil orders of protection, that we want to know if there's a violent person in the home that presents a danger to children. And child welfare agencies were given authority in 2006 to access this information. And some agencies even have gone further because they have authority to actually get a terminal, an actual computer terminal to link in to, that links in with the NCIC. They can actually get that terminal in the child welfare agency. They don't need to go through the police. They don't have to go through the state police. They get a terminal. They have to go through special training and security. And Florida was actually the first state to do this. And so I believe that this is a tool that is not being adequately used. And this is all about CPS accessing other information outside of child welfare that can be critical for child safety purposes. And I also suggest in the last bullet that state criminal history information on any adult who's in the home be accessible as part of an investigation. And Virginia has a statute that basically says if you're investigating, Child Protective Services investigating a report of abuse and neglect, you want to know who's in the home, because sometimes it's not clear who committed the abuse. Who's in the home? Well, let's look at the criminal history records on the adults in this home to see if that gives us any information that might be relevant. Virginia at least has a statute that allows that access. So earlier I talked about HIPAA, FERPA, and substance abuse records. And, you know, I've mainly been focusing on CAPTA, the Child Abuse Prevention and Treatment Act, and its restrictions on sharing information. But there are these other federal laws that are important. And actually, I get a lot of questions about HIPAA. And the question is, how does HIPAA apply to child abuse and neglect? And I wrote something about this years ago, and there's unfortunately not much out there on how HIPAA applies to child abuse and neglect. But what it does say in HIPAA and HIPAA regulations about child abuse and neglect is on this slide. So disclosure of abuse and neglect-related information is addressed in 3 sections of the HIPAA regulations. Restrictions on health record access do not apply, so HIPAA does not restrict release of health information where state law addresses the reporting of injury or child abuse or for public health surveillance, investigation, or intervention. And thus, I interpret that as health records should be disclosed to multidisciplinary teams, to children's advocacy centers, to child fatality review bodies, and to child protective services, as long as we consider that work deemed related to public health. And I would certainly contend that the abuse and neglect of children is a public health issue, is related to public health, even though the agency that responds to abuse and neglect is not the public health agency, it's a social service or human services agency. It is a public health. I wish HHS were to say clearly what I just said, but that's my interpretation of it. The HIPAA regulations go on to be clear that parents can't prevent release of a child's health information or even obtain that information if the medical institution has a reasonable belief they've subjected their child to abuse or neglect. And finally, that HIPAA gives police, courts, and those determining the cause of child deaths the ability to access relevant health information. So the HIPAA privacy rules don't get explicit enough about how HIPAA relates to abuse and neglect, but they say some very important things. And it's very clear that HIPAA in no way, it's been very clear, HIPAA in no way inhibits a doctor reporting abuse and neglect and revealing the name of the adult, even if that adult is their patient who abused and neglected their child, as long as there's a mandatory reporting law in the state. HIPAA is very clear about that. FERPA, Family Educational Rights and Privacy Act. I already mentioned the Uninterrupted Scholars Act. It actually amended FERPA. FERPA is a law that protects the privacy of a student's school records. And, you know, it's a very strict federal law to protect the confidentiality of school records. But in 2013, the FERPA was amended to allow for school record release to child welfare agencies so that educational records could be provided to child welfare agencies without the consent of the child's parents, and eliminated an earlier requirement that schools notify parents before records are released pursuant to a court order where the parent is subject to a child welfare court proceeding. So what it's doing, it's recognizing that child welfare agencies have a vested interest in knowing if a child under their care and supervision is in school, is going to school, how the child is doing in school, and that there shouldn't be a barrier, including a parental barrier, to accessing that information. That's what the Uninterrupted Scholars Act does. FERPA has also always allowed release of directory information. So here's information that has never been prohibited for release by schools. The dates of a student's attendance. You know, if a child is in foster care and isn't going to school because they're skipping school, and child's in foster care and the government has a responsibility for that child, shouldn't the child welfare agency know that that child is truant from school? Well, the directory information exception has always allowed the school to release information on the child's school attendance. So clearly, as the slide indicates, Child Protective Child Welfare can clearly check on whether a child known to them has been chronically truant or recently absent. And the slide says, what about a homeschool child? I think there's a real problem. I mean, I don't want to suggest that we pass laws and policies inhibiting the right of homeschooling. But we know of cases where homeschooled children have suffered severe harm and even death because they're not going to school, no one's checking in on them, and they're hidden from public view. That's going to be a very small number of cases, but it suggests that child welfare, when it has a case of a child where there's been a report and substantiation of abuse or neglect, that we need to be able to access information on what's happening in a homeschooling situation. And I'm not sure that adequately is addressed in law at the present time. And finally, on FERPA, students' educational records can only be redisclosed to those addressing the student's educational needs authorized by the agency to receive those records. But again, what does that mean? If the agency gets the school records, can it provide that information to the foster parents? Can it provide that information to the child's attorney, guardian ad litem, or CASA? Again, the policies are unclear about the redisclosure by child welfare of educational records to these other individuals, and I think we need clarification. Alcohol and drug abuse. We know the sizable percentage of families involved in the child welfare system involve parents with substance abuse problems and parents who may be in substance abuse treatment. However, there are strict protections on privacy afforded to clients of substance abuse treatment programs that are federally assisted. And you have the reference to the law and the regulations which address this. They're pretty broad, these provisions, on protecting information on the identity, diagnosis, prognosis, or treatment of patients. And again, I want to stress, in federally assisted substance abuse treatment, law and policy, well, the law actually dates back to 2008, and the policy, I think, is 2010. And yet, 4 years after the policy's been implemented, some very knowledgeable people in my meeting this morning said, gee, I didn't know about this. I mean, there should be a seamless sharing of information between child support enforcement and its access to parent locator information, which is very exhaustive, which can also be used for not just parents, but relatives and siblings of a child pursuant to federal law. There should be seamless integration of coordination and contact between child welfare and child support enforcement. And if it's not happening, it needs to happen. But as you see on this slide, there are a number of states that have memorandums of understanding or agreement on the interagency sharing of information, of how we overcome privacy barriers in a responsible way to share information that needs to be shared. And my final slide. Number 3, CAPTA should be amended to provide, and new state laws should promote targeted financial support for maintaining effective state and local multidisciplinary teams that address child abuse and neglect. We've known for decades that the best way to look at child abuse and neglect cases is in an interdisciplinary group where different professionals come together and look at cases through a set of multiple perspectives. Children's advocacy centers do this in their work, but it should be done for all child abuse and neglect cases, this multidisciplinary approach. But the only way for it to work effectively is to have adequate funding and to have state laws that assure that these multidisciplinary bodies exist. Florida has had regional multidisciplinary child protection teams for many, many decades. And it's something that federal law should promote. By the way, CAPTA, this federal law that I've been talking about since 1:30, CAPTA is up for reauthorization in 2015. So Congress, if it were going to get to CAPTA in 2015, which I'm not sure it will, but the authorizations under CAPTA of federal funding actually expire at the end of 2015. So next year, Congress should be looking at CAPTA. And there are lots of things that one could look to for CAPTA in terms of improving sharing of information, of eliminating barriers that restrict the flow of information that can compromise the safety of children. And I believe that there's an opportunity to do that. Number 4, CAPTA should be amended to tie Title II funding under CAPTA, which is about $100 million for community-based child abuse and neglect prevention, to tie that funding to an independent, careful review and implementation of the findings and recommendations of the state's fatality and near-fatality review teams. Somebody needs to independently look at the child death review team recommendations and to look at them as a whole. And what was done as a result of making these findings? What was done as a result of making these recommendations? There should be an independent, careful look at that. And I believe that could be mandated by CAPTA. Also, number 5, CAPTA and state child abuse and neglect laws should be amended to give explicit authority to Child Protective Services to subpoena the production of documents, records, and other materials deemed relevant to an investigation of child abuse or neglect. I believe that there should be authority of Child Protective Services to obtain investigative subpoenas and other ways of just not having roadblocks and barriers to getting the information that Child Protective Services needs to determine whether a child is safe. And finally, number 6, CAPTA, the Department of Health and Human Services, and the states should all provide a mandate to promptly share an agency's, organizations, and individuals' information with other agencies and professionals engaged in work to protect children. We have to go from a focus on tight restrictions on confidentiality, which I completely understand why in 1974 they were put into the law. And if someone accused me of abusing and neglecting my child, I would be very concerned about who had that information. But on the other hand, we cannot allow confidentiality and privacy and the ability of agencies to keep its information from both the public and organizations and agencies that have a responsibility to protect children. We can't allow the laws and the interpretation of those laws to inhibit successful sharing of information to protect children. It is a fine balance, and that's what this title is: confidentiality, transparency, and accountability, a delicate balance. You know, there are civil rights involved here. Nothing is worse, or there are a few things that are worse than being accused of abusing and neglecting your child. The stigma associated with it. I fully understand why in 1974 Congress used that language about how privacy and confidentiality was essential to protect the rights of the child, his parents or guardians. But I think they misunderstood in Congress that protecting the rights of the child is not served always by keeping information confidential, is not always served by restricting access to information by other agencies that are responsible for preventing child abuse and neglect, for providing services to abused and neglected children and their families. So we've got to readjust that balance. We have the Congressional Commission that's going to be issuing its recommendations to Congress. I imagine that's going to impact on CAPTA reauthorization. They, I believe, are going to wrap up their hearings in the next couple of months, and then they are going to issue a report with recommendations. And I know it's going to address these issues because that's why they held a session in Florida that looked at this issue of privacy and confidentiality. We have a system now that, and newspapers that have reported on child deaths know this, we have a system now that shields information in a way that compromises the safety of other children. And we got to do something about that, and the law can do something about that. So with that, let me take any questions that you have about privacy, confidentiality, information sharing, how this is working in Georgia, what things you think are related to information sharing that I didn't talk about, or that you consider to be very important in terms of how the system operates in Fulton County, DeKalb County, or in Georgia generally. So let me open it up, and there are microphones. And I'm told that please, if you have a question or comment, to use the microphone so that they can capture it for the
Okay,
folks.
do I have this on? Yes. This may be fools rushing in where angels fear to tread, but the state legislature in Georgia, and I imagine in quite a few others, it only meets for 2 or 3 months a year. And I just can't imagine those people getting together and coming up with a comprehensive bill to fix everything that you've outlined in your presentation. And I am just curious whether this particular slice of law isn't an area for a uniform law group that would propose something. There's a good legal housekeeping seal of approval on it, and it's bite-sized to the point where the legislature can just say, pass it,
Yeah.
like it does other uniform laws.
Yeah, that's a really interesting and good question, because I have done work with the National Conference of Commissioners on Uniform State Laws, and you know, there actually are several uniform acts that relate to child protection. There's one on alternative testimony of children in abuse and neglect cases. There's a uniform act on child representation. So NACUSL, or it's the Uniform Law Commission, has dealt with some of these issues, but I don't think they would get involved in this. I wish in some ways they would, because you're right.
You might want to suggest it, because all this is so complicated.
It is
and
complicated.
Legislatures make lots of mistakes in drafting laws when it gets towards 5 a.m. on the day before the last day of the term.
Yeah. Here's what you're absolutely right, because here's what you don't want. Legislatures passing laws instinctively after a child dies, because the newspapers publish a series of stories and everybody gets very agitated over the failures of the system, and somebody comes up with a law which they invariably name after the dead child. It's not coincidental that Alyssa Izquierdo's death resulted in Alyssa's law. It's not inconsequential, and he's a dear friend of mine, John Walsh, that the Adam Walsh, his dead son, Adam Walsh, the federal law is named the Adam Walsh Act. We get these laws that are basically based using the names of dead children. What you want is, whether it's a government agency that can study this and report to the legislature, like your Office of the Child Advocate, whether it's a legislative study commission, whether it's because you're right, a part-time, even a full-time legislature, this is a hard thing. Even a legislature that meets full-time, it has a specialized committee dealing with human services and child welfare, this is a tough nut to crack. This is really, you're right, this is really complex stuff. In some ways, it's unfortunately too outside of the way I believe the uniform commissioners think in terms of a uniform state law. But you're right, having models would be good. And it may be the Commission on Child Fatalities, the presidential congressionally created commission, that they will recommend some sort of model law that addresses these things, so that states can take that model law and implement it. It's a really excellent question. Thank you.
Thank Director Davidson for being here. We really appreciate it. It's really been an honor to spend the day with you and learn.
Thank you.
about the federal laws that affect children. And I just want to remind you all to make sure that you complete your evaluations and hand them at the registration table.